Hello students, there is a good news for you. Now you can write the same matter at different speeds. Link of the same is given in the description box. Thank you. Start. This is a reference by the Sessions Judge under Section 438 of the Code of Criminal Procedure recommending the setting aside of the order of the magistrate dated 2nd July 1958 by which he recalled his previous order of discharge dated 11th June 1958 and summoned the accused persons afresh. Stop. Para. The facts are that on 5th November 1957 the complainant instituted a case before the town police for prosecution of 4 persons for the offence of theft and cheating under sections 379 and 420 of the Indian Penal Code. Stop. Eventually, the police submitted charge sheet against them and the sub-divisional officer took cognizance of the case and transferred it to Judicial Magistrate First Class for disposal. Stop. Para. Upon a consideration of the documents before him and after hearing the parties, the magistrate formed an opinion that the facts did not disclose commission of offences under sections 379 and 420 IPC. Stop. Accordingly, he discharged the accused persons under section 251A. Stop. On 13th June 1958, an application was made on behalf of the prosecution for revival of the proceedings on the ground that certain matters had not been considered. Stop. He issued notice to the accused persons to show cause as to why the previous proceedings should not be revived. Stop. Cause was not shown by the accused, and on 22nd July 1958, on fresh consideration of the record and the case diary, the magistrate was satisfied that the discharge of the accused under section 251A was not justified and that there were sufficient materials to establish prima facie the offences under sections 379 and 420. Stop. Para. He observed that the previous order of discharge was based upon the documents which did not form part of the case diary and which had since been withdrawn by the parties filing them, suggesting thereby that on the strength of those documents the accused should not have been discharged. Stop. Accordingly, he recalled the order of discharge passed by him on 11th June 1958 and summoned the accused persons. Stop. It is this order whose reversal the learned sessions judge has recommended. Stop. Para. In support of this reference, he contended that the learned magistrate was not competent to revive his own order by which he discharged the accused on 11th June 1958. Stop. It has been urged that when the magistrate passed the order of discharge, he became functus officio and therefore he was unable to rehear the case stop. He referred to Section 369 of the Code of Criminal Procedure, which provides that no court, when it has assigned its judgment, shall alter or review the same except to correct a clerical error, and contended that the order of discharge is a judgment and therefore the magistrate could not revive the proceedings of his own accord, because it would be tantamount to reviewing his own order, which is prohibited by Section 369 IPC. Stop. I am unable to accede to this unqualified and broad proposition of law. Stop. Para. It is against the weight of authorities. Stop. The Code of Criminal Procedure does not define what a judgment is. Stop. Section 367, however, lays down the contents of a judgment and states what must be in a judgment. Stop. It states that it shall contain the point or points for determination, the decision thereon, and the reasons for the decision. Stop. This section, however, applies to the provincial criminal courts. Stop. Section 370 is applicable to judgments of presidency magistrates. Stop. It only provides for certain particulars being mentioned in the judgment. Stop. But in all cases in which the presidency magistrate inflicts imprisonment or fine exceeding rupees 200 or both, a brief statement of the reasons for the conviction has to be recorded. Stop. Para. An examination of the various provisions of the code will show that every order passed by the magistrate under the code is not a judgment within the meaning of Section 369. Stop. In order to constitute judgment, there must be an investigation of the merits of the case on evidence, and after hearing the arguments. Stop. Where, however, the order is passed summarily without consideration of the entire evidence, as in the case of the order of discharge, it will not obviously amount to a judgment. Stop.